Great. Good afternoon, everyone. Thank you very much for joining us. This is the top 5 legal risks facing SME businesses in 2025. My name's Sarah Clark. I am Chief Revenue Officer at the Legal Director. I'm a former barrister and General Counsel myself. At the Legal Director, or TLD, we work every day with SME businesses who want to grow, and they want to do that without being tripped up by legal risk. So today I'm joined by 3 brilliant panelists who bring real world experience across finance, law, and operations. And I'm going to let each of them introduce themselves. So, Carrie, let's start with you.
Thanks, Sarah. And thanks for having me today. My name's Carrie Jo Baker. I'm 25 years experience of working in finance for private listed, regulated backed businesses. I spent the last 6 years working with SMEs providing fractional CFO services, helping them to build out their finance function and help them realise their strategic growth plans.
Brilliant. Thanks, Carrie. Should we go to you, Natalie?
Thanks, Sarah. My name's Natalie Romain. I'm a fractional in-house lawyer working for TLD. Over the last 20 years or so, I've worked across a number of different organisations, and so I know what the real life struggles of an SME are from a legal perspective. I've seen a lot, and I really get how important it is for advice to be what I call the 3 Ps, which is practical, pragmatic, and proportionate. And I've seen, from governance issues through to contract issues, through to risk management, and how SMEs need to juggle. And so I look forward to discussing some of those points today.
Brilliant. Thanks, Natalie. Kirsty, over to you.
Hello there, I'm Kirsty Penk. I am the COO and co-owner of the Legal Director. I was an in-house lawyer before I joined Ed Simpson back in 2009. I am responsible for operations at the Legal Director, and I speak to a lot of SMEs about the challenges they face and how, frankly, the traditional law firm model doesn't support their business. And I explain how we at TLD do things legally differently. And how we live our purpose to be accessible, different, and human. So looking forward to today's discussion.
Brilliant. So focusing on why we're here today, I guess although the UK has technically avoided a recession, SMEs are still losing value, billions of pounds of it. And a recent study put that number at 13.9 billion a year. And what's causing that isn't the kind of headline grabbing scandals and litigation. It's everyday legal risks that we see all the time at TLD that all too often just fly under the radar and cost serious time and money. So today's session is about giving you really practical ways to keep that value inside of your businesses. And so let's get going. We're going to cover the 5 big risk areas that we see again and again at TLD, which are employment, contracts, both on the supplier side and on the sales side, cash flow and the erosion of cash flow, and governance. And for each of those areas, we're going to talk through what the risks actually look like on the ground, why they matter, and importantly, what practical steps you can take today, this month, this quarter, to get on the front foot. We've deliberately kept the session really focused on real world solutions so that you can walk away with tangible actions, not legal theory. So let's get going and dive straight in, starting with employment. So what I see speaking to SMEs is that employment risk is often invisible until it isn't, and then it's expensive. So we want to talk about how we make those risks visible so that SMEs know what they're facing into and don't get nasty surprises. So if it's all right with you, Carrie, I'm going to come to you first. I guess in your role as a fractional CFO, you must see a range of SME businesses. So what are you seeing in terms of employment risk?
Yeah, absolutely, Sarah. It's a key area of issues that I've seen in my clients. One of the biggest issues I see are multiple exits of people. So poorly drafted employment contracts that when you really need to rely on them, they're not giving you the enforceability that you need. And the exit then is dragging both in cost and in time. And these things don't just cost money. They absolutely take a significant amount of time to exit a person. I think it's obviously we've mentioned the drafting of the contracts, but it's also about like, have you got the right clauses in place, the restricted covenants? In my book, not having a restricted covenant can be almost as bad as a poorly drafted one. So ultimately, it's making sure that at the outset that these clauses are drafted appropriately, because otherwise when you come to exit you are literally left with nothing, and not only are you left with a costly legal bill, you can lose clients, revenue erosion, and I think that's one of the biggest things that we need to manage. I think even when the settlements have been agreed between the lawyer and the exited employees, there's further risks that I see come to fruition. It's we think client signed an NDA with the exiting employee, but ultimately they can still come back with further subject access requests, which can be further damaging, lead to further, legal issues that they will raise against the firm. And then ultimately that's time consuming as well as the damage to the client or to the SME's reputation. I think I also see that they don't often, it's really hard to enforce an NDA. Let's be honest, it's there. And you sign it and you think that's going to gag the employee that's leaving. But in often situation, it doesn't. And then that then gets around, and then other people want the same arrangements. And then ultimately your opportunity to attract talent is flawed, I think. So all of those issues can wrap up into, they are cost drain, but it's the time drain as well. And time is money as well in these businesses. You're, not lots of people doing these jobs. And I think the last point I'd raise, and maybe then you'll move to Natalie to respond, is, as clients grow, or my clients, so SME clients grow, they expand into new territories. Often at that point, they will invest in a new contract and legal advice to support, but then that opens up risk areas in their existing their existing employment contract base, which then means you've got a diversification between one territory and another. One could be more costly than the other. So I think, being very aware up front about what your employment contract should have in, and as you expand is quite key. The number of issues I see, but hopefully you and Natalie have some things to say about that.
Yes, so I guess what you're saying is it's kind of the crystal ball effect. It's the stuff that you don't foresee down the track. It's not just the immediate risks that are staring you in the face. It's what kind of gathers momentum after the event itself. So, Natalie, you spend a lot of your time within SMEs. What are the legal options that are available to SMEs in these kinds of situations that Carrie's articulated?
Yeah, so Kerry's absolutely right, and often I come across those issues that largely stem from companies that obviously started small, just, put in some kind of basic employment contracts, didn't really, didn't have that crystal ball, Sarah, that you mentioned, or certainly it wasn't working very well at the time. And so therefore, as they scale and grow, those arrangements no longer serve their business in the way that they should. And as Carrie mentioned, the risks of that are many. They're expensive. You can lose intellectual property. You can lose clients, customers, all of which is very expensive. And so what I would say is the key thing for an SME to do in a practical sense is to, just get out your employment contracts and have a good look at what they say, especially around key terms like intellectual property. Do you own everything that your employees create? It's not a given. What are your termination provisions? How do you manage an exit of particularly a senior person in your business who has, very strategic relationships? Do you have restrictive covenants? And even if you do, are they compliant with current case law? Case law is always changing for restrictive covenant practice. And so what might have been enforceable 5 years, 10 years ago, that's not necessarily the case now. So, you do really need to sort of know what you've got in the filing cabinet. It's not easy to retrospectively change employment contracts. So there are some practical things you can do if you perhaps haven't got the protections that you might like in there. One of them is to put a template NDA in place, which you can use for project-specific matters where perhaps there's some sensitive discussions around IP or trade secrets or customer lists that are being disclosed to a group of people. And so what that does is it protects your business on a case-by-case basis, as opposed to at a grassroots level, which an employment contract would conventionally do. And, then I would also suggest that you make sure, Carrie mentioned data subject access requests, they are used as a bit of a weapon in employment disputes, and for good reason, because they're incredibly time consuming for a business to deal with. And there are penalties for not complying with the instructions of the ICO. So make sure that you've got a process in place for what happens when a DSOR comes in. It doesn't have to be long. It doesn't have to be complicated. It just needs to be clear who's in charge of receiving those requests, who's going to start the timer, and then what happens then. Who is going to be responsible for collating that data and disseminating it to the employee. So I think there are a couple of things in addition, one which I'd quickly mention, which is just review your policies as well. So, often employment policies are a bit of a headache, and I can almost see everyone rolling their eyes. But, I think if you have a good employment handbook with up-to-date policies, it can also help you deal with grievances, health and safety issues, and any other number of issues that are around remote working, flexible working, because you're then dealing with all of those matters consistently, which then protects you down the line in terms of, any disputes that might arise. So that would be some of the things that I would suggest.
Thanks, Natalie. I think they're really practical. I love the suggestion about a project-specific NDA, because I just think that's such a tangible, quick thing that businesses can do that probably not a lot of businesses know they can do. They sort of think they're stuck with their not very good employment contracts, in terms of protecting their sensitive information and so on. And just being able to put in place a project-specific NDA for whatever it is that you're doing as a business that's strategic and complicated or secret is obviously a really practical and tangible thing that businesses can do. So thank you for that. You mentioned updating policies and things like that. And actually, I was going to come to you, Kirsty, on that, because something I know we see a lot at TLD when we're speaking to SMEs are businesses who've kind of created a bit of a false sense of security because they've outsourced their HR, their policies and so on to some sort of outsourced HR provider. But actually, well, you tell us what they're finding is that they're not as protected as they think they are when they sign up to one of these kind of outsourced solutions.
Sure. Yeah, we see that a lot with businesses, and what they'll often do is for a few £100 a month, they'll have subscribed to this service, which gives them policies, obviously a completely sort of off-the-shelf policies that they can just download, and also gives them a process to follow in the event of any disputes. So often the issues there become they're really regimented in their approach. And there's no kind of flexibility around the advice they give you, and businesses just find very quickly it becomes pretty much not fit for purpose. What there's also an element with those services often is there's an insurance policy that sort of comes with the service, which sort of notionally says that they will pay out in the event of a tribunal claim. And what we see in particular with those is that it really pushes businesses into settling disputes over trying to find a solution for them. And it opens up an SME to look like they're a bit of a soft touch, frankly. And that can just have a bit of a snowball effect when businesses really sometimes want to fight these claims. So that it puts a stake in the ground to show previous so future employees that they're not a pushover. And these policies very much are geared around pushing you to settle, and also, frankly, not really paying out in a lot of situations unless you exactly follow their rules. So I think our message really is that it's just a bit of a false sense of security sometimes. And in our opinion, there's no sort of substitute for having a really sort of practical a sort of handbook that covers all of the issues you might want to deal with as an employee, an employer, have the policies really clearly laid out, and have some training on that internally in the business.
Okay, great. So Natalie's kind of given us the tangible quick wins that businesses can do for themselves. But then obviously those things that you just outlined are things that we're obviously able to come in and support on. Absolutely. So, to avoid the don't know what you don't know effect, which is, I think, what we were just talking about. So I guess just to sort of summarize before we move on to the next risk, I think what we've seen is that this is about tightening up contracts and processes up front rather than putting yourself in a situation where you're trying to sweep it all up in a firefighting exercise after the event where it gets very snowbally and very costly. So it's not about, over engineering these things. It's about putting in place some very sensible and commercial guardrails, not kind of over engineering and being overly legalistic about it. So moving on to contracts, which I guess, clearly divide into two camps. You've got the supplier contracts, so people that are delivering goods and services into your SME business, but also then your new customer contracts, your sales contracts, which in many businesses is the kind of lifeblood of the organisation and the way that revenue lands in the business. And I speak to a lot of CFOs in my job, and a couple of the things that I hear consistently are, one, that they're drowning in contracts, that they're the CFO and yet they've got stacks and stacks of contracts on their desk that are stopping them getting to the day job, or in fact that they are creating delay by not having the bandwidth to get to those contracts. And two, that whilst those contracts should be protecting the business, what they're actually doing is creating delay because the processes aren't in place to kind of review them quickly and efficiently and so on. And so then that, when it comes to sales contracts, that means a delay in revenue landing, which is obviously not good for anyone. So that's what I hear. So I guess it's important for us to look at how SMEs can protect themselves from those two things amongst others and kind of keep that pace of commercial growth. So Carrie, coming to you, what, in your experience, do CFOs spend their time on when it comes to contracts? What's taking up your time?
Yeah, I think I agree with your observations, Sarah. It's often the SME doesn't have an in-house legal resource, and it does always land on our desk, and we're not lawyers. We're often very keen to see a contract from a financial perspective, but there's so much more to that contract review. If we take client contracts first, I'm always really keen to see contracts on our paper, but so often I see SMEs like signing up to, the client terms, which often can erode the ability for us to maybe collect payments for the revenue on time, or they're holding us to more draconian milestone, deliverables than I would potentially like. I think, the enforceability of collections is one thing, and I think also sometimes I see poorly drafted contracts around, the opportunity to charge interest on, the absence of payment. And it's silly things like that can get overlooked because they look at the core and then they forget those financial terms. So for me, that is an issue. I think, from the revenue delay point of view, you're right. You've got a whole pile of contracts on your desk. You want to make sure that they are tip top and everything is okay, which is why they stay on the desk for that bit longer. But equally, weeks turn into months, and then all of a sudden you're 2 to 3 months later in implementing a client, and you could have foregone that revenue. So I think there is a real balance about investing some costs to pay for a legal review of those and have a more centralized process rather than relying on a CFO to do it, because it's not the best use of our time. I think supplier engagements, where I've seen in real life examples of this go wrong is that often the business will sign up to like a 2-year software contract, and often, we're all led down the path by a fancy sales demo, but unfortunately, when it really gets to it, they've signed up to 2 years. The scope's not there. It's not quite fit for purpose. So it's either very costly to exit and then go again, or you're stuck with a piece of software that's actually going to take much longer because you've got to do a load of bespoke development. So you're not getting the value of the contract that you've subscribed to, say, 3 or 4 months ago. So I think really understanding what you're signing and making sure that the contract, whether it's client or supplier, is fit for what you expected it to do. But that's where people cut corners every single time. So maybe having an in-house legal resource will really help with that. I think the other thing that people sort of misunderstand is that if you're a business that's trying to grow and scale and needs external investment, whether that be through some sort of financing facility or whether an M&A transaction's on the cards, they look at your top or your critical client and supplier contracts. And if you've not thought about it and it's not impacting your business, then it could impact your business down the line. And I think that's when it's really important to understand what you've signed up to. And I think the ability to raise finance, you might not be able to raise as much as you like because you've got too much concentration on one client, for example, or their payment terms are too draconian for what the financing company wants. So I think it's also having who said the crystal ball earlier, it's also knowing about how people will review these contracts down the line in that sort of event. So it's obvious to say pace is really important, but I'm an accountant, so I need due diligence as well. So it's getting the balance. So yeah, I guess maybe Sarah, you can bridge to Natalie and see what she's got to say about that.
What I was just thinking when you were speaking actually was that whilst it can sound like every single contract needs a kind of legal review and legal eyes on, I think what I'd like to ask Natalie about is, how do we avoid that? No business wants every single one of their contracts to be reviewed by a lawyer, whether that's in-house or external, or a fractional in-house lawyer. So what kind of things do you implement, Natalie, when you go into SMEs to kind of help them be a bit more self-sufficient and kind of create that internal capability?
Yeah, thanks, Sarah. I think that there are a few things, and I think particularly with some of the tools that are coming out now, this isn't self-service becoming very doable for companies, in conjunction with sort of some interim support to help them get to a place of sort of sufficient clarity on their own terms and conditions. So what I would always recommend is having some good templates to start with. Have a good customer, set of customer T's and C's or a customer contract. And I understand it's not always possible to get it on your paper, but wherever possible, it should be really pushed for. And in a similar vein with your suppliers, have a clear sort of playbook of supply terms which are and aren't acceptable, and communicate that to your procurement team so that they aren't accepting risk positions which aren't aligned with the company's risk appetite. So just flipping back to the customer contracts, you can put in place a great template, and then you can train your sales team with contract guardrails, and what that does is it creates an ability for that team and those individuals to speak to customers and get contracts in place, while observing the company's limits on risk, and they know what's acceptable, what's not. They know what an alternative clause is. If perhaps clause 1 doesn't work, then perhaps we can have an alternative, and that's the backstop position. And if a customer still won't agree, that then it gets escalated. So what lands on the Carrie Joes of the world's desk isn't a 25-page contract. It's Carrie, we just couldn't get them to agree the limitation of liability at X amount, which is all I'm permitted to agree. Can we increase it? And so having a good clear line of sight on what your contracts are. A contract register doesn't have to be fancy. It can be an Excel spreadsheet, so that what contracts you've got in your business, supply and customer, is equally important, because then you can actually do a bit of a risk analysis on perhaps have you granted unlimited liability in any of these, because these are the things that are going to matter to an investor incoming. They're going to want to know, do you own your IP? You haven't given any of that stuff away in your customer contracts. Can you get out of that hideous supply contract that you entered for that piece of software that you don't use anymore? So having a good contract spreadsheet up front to help you actually work out where your risks are is probably as important as then having those templates in place to start mitigating some of those risks that are being created by not having those tools.
Yeah, and the exercise, it sounds like the really critical exercise that I think people, in my experience, people don't always make the time for, but is at the kind of foundation of all of this is standing back as an SME and saying, well, what is our risk appetite and what do we really care about? And, what is the secret sauce and what is the bet the company stuff? What is it that we really care about as a business that we want to protect? And then all of those things, Natalie, sort of flow from there, don't they? Because then you can create your kind of guardrails and say, this matters, this doesn't matter.
Yeah.
Procurement contracts, these are our hard lines. And so I guess it's, taking the time to kind of wrestle with that tricky thing as a business to sort of lay down the foundations to say, this is what we care about.
Yeah, definitely. And I think, we'll talk about this a bit later in our governance piece, but also, getting the board on board with that, having that as a documented, position, and sort of a risk management policy really is what I would always recommend that an SME has.
Yeah, and even if it's not complicated, it's just having that buy-in, isn't it, from the relevant kind of leaders in the business. Look, guys, do we all agree on this? Is this our risk appetite? Because then we're going to lay it down and say, right, this is the sort of baseline, and then you can do that. And what have we already signed up to, and how far away are those contracts from what we say our risk appetite is? Yeah. So, Kirsty, from a kind of TLD perspective and the services that we offer to clients and the things that we've really been able to support clients with, obviously, all SME businesses have contracts. So, what are the kinds of things that our team are doing in SMEs when it comes to contracts?
Okay, I think there's a couple of interesting points that were made there. Carrie Jo very much articulating what we hear from CFOs a lot, which is kind of they get dumped with all things legal, and it's not necessarily their skill set. And I think giving CFOs the tools to allow them to take a step back from that and really kind of manage their workflow so that they don't become a bottleneck, and put in place all the things that Natalie talked about in terms of templates, guardrails, playbooks, and ultimately training on the business to become as self-sufficient as they possibly can without needing to go to a lawyer at all. And I guess the other thing just to mention is when we first go in to a business, to a new SME, when we're usually doing our sort of 3-month trial arrangement, we will work really closely with them to work out what is their risk appetite and to really nail that, because it's very difficult to review any kind of a contract or give any kind of legal opinion on anything if you don't understand what the really important things are for the business. And I think once you've kind of conducted that exercise and everybody's really clear on that, it becomes a lot easier process for everybody to manage. And obviously it gets this stuff off the CFO's desk.
Yeah, absolutely. Natalie, you've gone through this exercise with an SME client quite recently, haven't you?
Yes, that's right. So it was a specific task, so on an NDA actually, and it really was providing the SME with a template NDA that they could use. But there are different situations when you'd use an NDA. So really what I did was I worked through what those situations were with the client, and then drafted 3 different NDAs. They didn't vary wildly, but they just had certain different provisions for different situations and created, like a 1-page guide, say, in this situation, use this one, in that situation, use that one, and why. And so what that meant is that the CFO who I was working with and provided this to could then cascade that to the business with my, which was plain language note. And so they could really just, pick up that note and then use whichever template was suited to their needs. And I think it's worked well.
Brilliant. I think that's a really great call out actually for kind of the difference between having an in-houser, an experienced in-houser come in and support you versus, the kind of traditional law firm model, because they'll always be looking at it from the risk perspective, from the business perspective, and also thinking about, how do we create this self-sufficiency within the business so you don't have to have a lawyer looking at everything that you do. So I guess it would be remiss of me not to point out at this point that if any of the issues that you're listening to us talking about feel sort of familiar to you, something that we offer is a free business risk scan. So one of our team will speak to you as SME business leaders about your business in some depth to actually understand what your risk profile is, and then kind of map it against where you are in terms of your processes and so on, in order to give you a bit of a heat map to say these are the things that you really need to be worrying about, and here's how you might action it. So if that's something that you'd be interested in, the free business risk scan, then please click on the button on your screen now, and one of our team will be able to contact you with a free assessment questionnaire. So do that if that's of interest to you, and we will move on to cash flow risk. So we've obviously just been talking about contracts, contract management, but one of the sharpest places that I think that legal risk shows up in an SME is in cash flow, and it's something that all SMEs obviously care about enormously. So when payment terms aren't clear, for example, or collection processes aren't robust enough, the impact on an SME is immediate and painful. So I think we need to think about how we build in those legal protections to make sure cash moves through the business in the way that it's intended. Carrie, CFOs are no doubt very, very focused on cash flow. So tell us what you see in businesses from a legal risk perspective.
Yeah, it's that lovely accounting phrase, cash is king, Sarah. All things lead to cash, don't they? So, we talked a little bit about it when we were talking about contracting, but to me, it's very much, we just need to understand the risks that the business is facing to understand the impact on the cash flow. If we talk about collections, particularly, because that's obviously the mainstay of the cash flow into the business, it's more than just having the contractual terms that Natalie has referenced, that you have standard clauses in place. It's also understanding what your robust credit control process is, and often having a legal insight into that. So what do I mean by that? Having a very standardized process, a set of legalistic letters that escalate with the aging of the debt profile, the enforceability of an interest penalty for late payment, and sending that letter. Because often, I've seen this, as soon as it gets onto my desk and I say, right, send the interest letter, that can often trigger payment, often without the interest charge, but I'll take that. But it's having that standard, that ladder process of at what stage should I send what letter, and having that drafted with some in-house legal resources very useful. I think also it's knowing when to cease the standard escalation of collections letter, and knowing when to go into legal recovery or write-off. And I think understanding your risk appetite to that, it does depend on volumes, etc. I think that's a really big area that people can really improve their cash flow just by having a very watertight process around that collections process. And that credit control in finance can just execute. They don't have to go to the lawyer, because you've done the work. You've pass that on, and you're giving the SME some sort of process to follow and self-serve at that level, which is very useful. I think also it's understanding the fact that, having high levels of debt does impact cash flow, but it can trigger covenants. If you've got financing arrangements in place, or, the bank's not happy with where you are. And I think sometimes people can overlook that, and they think revenue is really good. And then they look at their balance sheet, which is often not looked at monthly in lots of SME clients. And that's obviously something I focus in on, so they do understand the health position of the business. It's then making sure that we understand that we're not triggering any particular issues around any financing arrangements that may be in place. But again, as we touched on before, is also having a high age debt profile can limit your ability to get more finance or different types of finance. So I think anything that standardizes and structures the collections process is very useful. And I mean, I think all I would say is, if we don't see quick conversion from revenue to cash, the business dries up. You can have the best P&L in the world, but if your balance sheet's not as healthy, lots of businesses can go bust. So I think it's incredibly important to understand those legal risks. And then more broadly, I think, understanding any significant changes in your contracts and that are coming up that can impact cash. So again, having early sight. Natalie, you talked about contract register when it's up for renewal. Can you then renegotiate terms that can improve your working capital. It's also having an understanding of that. So I'm sure there's lots of processes that you would encourage Natalie to have a better, insight into that as well. So.
Thanks, Carrie. So lots of things that you're seeing as a CFO. So going over to you then, Natalie, what is it that businesses are failing to do or missing that's opening up to these legal risks, and what can they do about it?
Yeah, thanks, Sarah. I mean, I think there are a few things, and look, it's always going to be imperfect because you can write whatever you like in a contract, and we all know that sometimes it is hard to, well, you can't get blood out of stone, first of all, right? So but there are some things you can do to help support your cash flow from a sort of legal contractual perspective. Some of the things I often see are, as Carrie mentioned, people signing up to disadvantageous payment terms, not really checking what they are before they sign on the dotted line. Perhaps the contract doesn't have any clear contractual process for challenging an invoice. But one of the key things is actually, as a supplier, if you are supplying goods or services, you need to be able to suspend in the event that a customer doesn't pay you, and that is really important, because if it's not written in the contract, it becomes very complicated to do that. And so what happens then is, obviously you're not being paid for the services or goods you have already provided, but you may well be obligated to continue supplying. So it is really important that you have that ability to suspend, and down the line even terminate for non-payment as well. Actually specify it as a material breach, because it's not a given. The other thing, if we turn it on its head, actually, what I often see is just a lack of due diligence up front. SMEs just don't check who they're doing business with, and I get it. Often it's a case of just running at pace, but you do need to check who you're supplying to, and that they have the means to pay you. So you need to check their financial health. The other things I see in supplier contracts is perhaps automatic price rises. So look out for those. You don't want to be caught out. As Carrie said, make sure that you've got the ability to recover late payment interest. And have that, that collections ladder. So have some nice template legal letters that get sent at various stages of non-payment, because all these things, and Carrie mentioned this as well, affect your credit worthiness. And so investors, a high amount of bad debt is, will be scrutinized. Your governance and your processes will be scrutinized as to how that debt has been allowed to rack up, and mechanisms that may be available to you in a healthy cash flow state, like factoring or third party arrangements, won't be available to you.
Yeah, that's brilliant. Thank you, Natalie. I think that's it sort of comes back to this future proofing point again, doesn't it? It's not waiting until you're in the situation, just having the kind of the basic layers in place ready to implement when something goes wrong. So Kirsty, from a sort of TLD point of view, what are the sorts of things that we're able to support businesses with?
Sure, I think it's really key. The first approach we take is a very, very risk-based approach, because all the things we've been talking about, it only becomes really key on a slim number of contracts. So I think the key thing would be to look at, which are your really key agreements in the first place, and then look at, what can you do in a situation where those things go wrong. Do you need to make sure you've got shorter payment terms? Do you ask for cash up fronts for high risk customers? Just making sure that you've kind of assessed those really key contracts, and making sure that everybody within the business knows that these have got a special terms, and that they're kind of separately tracked, so people understand what the risks are. And we very much often work with SMEs to define, sort of supply thresholds. At what point will you say we are not supplying this business anymore? And you need to make sure that that is aligned completely with ops and finance, to make sure they're all aware of and aligned on the right trigger points for that. So that's kind of a couple of practical steps we'd be taking in that regard.
So I think what we've heard is we think of cash flow as being an exclusively finance issue, but it's very much something that legal can support with and change the risk profile of, and putting in place those sort of guardrails. Once again, you're not only protecting revenue, you're actually protecting kind of future valuation of the business itself. So yeah, really interesting. Thank you. And we're going to move on to our last risk, governance and compliance. And I think there's a sense that in SMEs, people don't want to overdo governance. You don't want to kind of over engineer it, but there are still aspects of board governance and compliance and regulatory obligations where a lack of awareness really exposes businesses to legal risk. And Carrie, this is probably something that CFOs sitting in boards and in leadership teams you see quite a lot of.
Yeah, I mean, like you say, governance is bottom of the pile. Even accountants don't like governance all of the time, you know. But I think, you know, in SME spaces, it's really easy, especially when there's multiple founders and multiple shareholders. You know, for me, one of the biggest governance areas that does come up is shareholder agreements. And it, you know, when you're all friends, it doesn't seem that big a deal. But at the end of it, you really do want an agreement that's in place. But as I've said all the way through here, I think Natalie talked about pragmatism. You want governance, but you want light touch and some level of flexibility within that. So for me, you know, a poorly drafted shareholder agreement is almost the same as not having one, because if it's poorly drafted or overly complicated, it's almost impossible to sort of like uphold and sort of maintain the integrity of what was intended at the beginning. So I think shareholder agreements is a big area for SMEs that they probably don't spend enough time on, and because it's hard to do, you know, without having legal advice. So I think that's a key area. And for me, you know, having to report against certain SLA, you know, and certain reporting requirements that the shareholders require, or as I said, unpicking, you know, a wind up, that's key. And I think, you know, it's the other areas which a lot of people think is just accounting, which is like the statutory disclosures or the statutory compliance. But actually, there's so many legislation changes that come about that actually SMEs don't fully understand. And if you don't have a seasoned CFO who can help you at least navigate some of that, it's more than just disclosing in the statutory accounts. Have we got the right employment rights? Have we got the right benefit disclosures going on in the accounts? You know, it's even as basic, Natalie, isn't it? You know, are the directors fully aware of their obligations? You know, and are they a smaller or a larger company? Those thresholds move. And, you know, they're open to a bit of interpretation. And I think, you know, having somebody who, you know, in-house from a legal perspective to help navigate that alongside finance is quite useful. So, yeah, I think that those will be the areas of governance that I see most conflict come up in the SME spaces that I've worked on. But as I said, it's always an area that's at the bottom of everyone's to-do list, but so incredibly important.
Yeah, interesting. Director's duties, I think, is something that you think is a given, but actually, when you speak to SMEs, it isn't something that people are entirely aware of. Natalie, what are you seeing?
Yeah, I mean, I think, as Carrie said, I mean, governance is, you know, probably, you know, at the bottom of the pile, and you know, with a big packet of ibuprofen next to it. So, you know, but you know, it is very important to get right, and it needn't be massively complicated for an SME, you know, in particularly in the early days, but it can't be ignored, because if you ignore it, you know, it will bite you at some point. And so, you know, having a founder or a shareholders agreement in place, which is, you know, relatively straightforward and just sets out the understanding of, you know, who owns what and what happens, more importantly, what happens in the event of a fallout, you know, that can really help save huge amounts of money down the line. And you know, another thing is, when you are onboarding new directors, you know, give them some training on directors' duties, you know, their duties under the Companies Act, Section 172, the duty to act in the best interest of the company. What does that mean? You know, why is it important that you understand what happens in, you know, if things aren't going well, you know, what do you do and why does it matter? Well, it matters because, you know, if you trade while the company is, you know, technically insolvent or can't avoid insolvency, there are penalties attached to that and personal liability as well. So it is really important that directors stepping into those roles, they understand those obligations. And the other key thing, which Carrie sort of alluded to, are the reporting requirements. So, and this comes to, having a contract with, clear terms so that you can recognise your revenue at the right point and therefore ensure that you're complying with UK GAAP, which most SMEs typically opt to comply with. So there's some of the key, I think, governance points that can't be avoided and shouldn't be. And then you've got other things as well. So it's making sure that if you've got a website that that it's compliant, that you've got website T's and C's, that you've got privacy policies, cookie policies, privacy notices. And then internally, you've got things like, a governance checklist that you take to your board meeting, perhaps, so that you can run through some of those things on a, quarterly basis or more frequently if depending on your size, and actually keep track of your health in that way.
Because it's going to be a moving feast, isn't it, as well? As businesses kind of morph and grow, as legislation changes, these things will start to apply to businesses that didn't apply the previous year or whatever it may be, thinking about things like modern slavery, reporting obligations and those sorts of things. And I think it comes back to something that we've touched on in other sections, which is the don't know what you don't know. You can't, if you're not a lawyer, you're a leader of an SME business and you're busy doing the day job, you can't know everything and you don't know what you don't know. So I think that's something that we come across quite a lot. Kirsty, what are the sorts of things around governance and compliance that we're finding that we're helping SMEs with?
Yeah, I think a lot of it is very much, along the lines of you don't know what you don't know. And it goes back to when we first start working with an SME in that kind of critical trial period, the first 3 months of an engagement, we will look at this kind of stuff from a basic risk register point of view to look at assessing risks across the business, but in particular looking at some of the governance risks and making sure that, some of these boxes have been ticked. And I appreciate fully that there's the very much the incentive for people and the desire just to download a load of stuff from the internet and kind of say, okay, that's fine. We've ticked our cookie policy off, for example. But I think a little bit of support at the outset of that, and just a sanity check. Just giving you the sort of security that's been looked at. First of all, that it's still valid. Secondly, that it matches your risk appetite as a business, and actually whether the business is implementing it, because it's great having some of these policies in place, but if at the end of the day they're just too rigid and they're not being implemented by the business, then they're not worth the paper they're written on some of the time. So I think it's a combination of looking at a risk-based approach and frankly ticking off the big things to start with, because it can become quite an overwhelming area for SMEs.
Yeah, and it's really practical stuff, isn't it? I think if you're an SME business leader, a lot of this stuff you kind of know in the back of your mind it needs doing, but it gets pushed because it's not the day job, it's not revenue driving, it's not the thing that's front of mind all of the time. And I think that's probably what makes it tricky, and for these things to sort of the boring stuff, as a lot of people would think of it, sort of just gets pushed. So to recap on what we talked about today, we've talked about employment, talked about contracts, and on both sides, the supply side and on the sales side. And we've talked about protecting cash and what governance and compliance is required within SMEs. And I think to kind of sum up, these aren't abstract legal concepts. They're kind of intrinsically interwoven into your SME, and they're everyday pressure points for growing businesses. And the reality is when you tackle them early, or you get them tackled, they stop being blockers to progress and to revenue and to growth, and they start being enablers. And I think that's something that people miss. I don't think people think of legal as a growth enabler. But I think what we've all seen from our different kind of vantage points at this panel is that it very much is a growth enabler and a revenue enabler. So thank you very much for joining us. If you would like help to understand your own legal risk profile as a business, then don't forget to click through for the business risk scan, and one of our team will be in touch to help you with that. It's completely free, and I would say just give it a go. It will open your eyes to things, to the don't know what you don't know, which is something that's come up a couple of times in this session. So my huge thanks to Kirsty, Natalie and Carrie for all of their insight and wisdom that they've shared with us today, and to everybody who's joined us. And I really hope that you all leave today with at least a few practical ideas that you can implement straight away in your businesses. Thank you.